The 87th legislature significantly revised the Texas laws pertaining to the carrying of a handgun by a license holder. In this screencast, we'll discuss the Penal Code offenses of trespass by license holder with a concealed handgun and trespass by license holder with an openly carried handgun. The 87th legislature made some significant changes to these statutes and many other laws in passing what is known as constitutional carry. Please note, this screencast isn't all-inclusive regarding firearms laws in the state of Texas. There are several other relevant statutes, including ones that carve out exceptions regarding places such as churches, schools, and other locations, so you should not consider this screencast as comprehensive or use it as legal advice on when or where you can carry a firearm in the state of Texas. This screencast is for academic purposes only and designed to explain the contents of Texas Penal Code sections 30.06 and 30.07 and these sections only. First, it's important to note these offenses pertain only to those carrying a license to carry a handgun under the authority of Subchapter H, Chapter 411 Government Code. These offenses do not apply to someone carrying a handgun under other circumstances. Next, these offenses pertain only to private property, or as indicated in the statute, property of another. Private property owners may determine whether or not they want a handgun license holder carrying concealed or openly on their premises. A person who is in control of private property that is a public place, such as a business, may permit concealed carry by a handgun license holder but prohibit open carry by a handgun license holder on their premises, or prohibit concealed carry by a handgun license holder but permit open carry by a handgun license holder on their premises, or prohibit both concealed and open carry by a handgun license holder on their premises. The first of the two handgun license holder offenses under Chapter 30 of the Penal Code is Section 30.06, sometimes referred to as 30-06. It addresses penalties for a handgun license holder who is carrying concealed on private property and without consent of the person in control of the property. The Penal Code states a handgun license holder who carries a handgun onto the property of another without effective consent, after having received notice that entry on the property by a handgun license holder with a concealed handgun was forbidden, or who remained on the property after being advised it was forbidden and failed to depart, commits an offense. Notice is familiar to us in the form of the 30-06 sign. The Penal Code provides specific written requirements for the sign, including that it have a specific statement on it, be in both English and Spanish, appear in contrasting colors with block letters at least 1 inch in height, and be displayed in a conspicuous manner clearly visible to the public. A handgun license holder with a concealed handgun who disregards proper notice, for instance, a properly posted and displayed 30-06 sign, commits a C misdemeanor with a maximum fine of $200. Should the handgun license holder then be personally given the notice by oral communication by the owner of the property or someone with apparent authority to act for the owner that they may not be on the property with their concealed handgun and they refuse to leave, the offense becomes an A misdemeanor. The 30.07 statute is very similar to the 30-06, with the exception of that it applies to a handgun license holder who is openly carrying his or her firearm. It states that a handgun license holder commits an offense if he or she openly carries a handgun on property of another without effective consent after having received notice that open carry of the handgun was forbidden. Just like 30-06, 30.07 has a sign requirement with specific language. The sign must be in both English and Spanish, be in contrasting colors with block letters at least 1 inch in height, and be displayed in a conspicuous manner clearly visible to the public. Also like 30.06, a handgun license holder with an openly carried handgun who disregards proper notice, for instance, a properly posted and displayed sign, commits a C misdemeanor with a maximum fine of $200. Should the handgun license holder then be personally given notice by oral communication by the owner of the property or someone with apparent authority to act for the owner that they may not be on the property with their openly carried handgun and they refuse to leave, the offense becomes an A misdemeanor. Since there are two separate laws, one addressing a handgun license holder carrying concealed and the other addressing a handgun license holder carrying openly, then there are two separate signs. Should a person in control of private property, such as a business owner, want to prohibit both concealed carry and open carry, they must post both signs. If they only want to prohibit one, they need only post the appropriate sign. Signs are probably the most frequently encountered forms of notice, but the statutes allow for other forms as well, such as passing out cards with the same required language printed on them. It is an exception to the application, which means no charges may be filed if the property on which the license holder carries a handgun is owned or leased by a governmental entity and is not a premise or other place on which the license holder is prohibited from carrying the handgun under Penal Code Section 46.03 or 46.035. There are several defenses to prosecution. First, it is defense to prosecution to both 30.06 and 30.07 that the license holder is an owner, guest of an owner, tenant, or guest of a tenant of an apartment, condominium, or manufactured home lot, and the license holder was storing their firearm in their residence or vehicle or traveling between the two. Next, it is a defense to prosecution to both Penal Code 30.06 and 30.07. The handgun license holder is a first responder, as defined by the Penal Code, which means a public safety employee whose duties include responding rapidly to an emergency and includes fire and EMS personnel, but does not include volunteer EMS personnel. The handgun license holder who is a first responder holds an unexpired certificate of completion under the government code, and he or she was engaged in the actual discharge of the first responder's duties while carrying the handgun and while employed or supervised by a municipality or a county. It is also a defense to prosecution of both 30.06 and 30.07. The conduct occurred on hotel, motel, inn, or a similar business at which the handgun license holder is a guest, and the handgun license holder was storing their firearm in their room or vehicle or traveling directly between the two. Finally, it is not a defense to prosecution of either 30.06 or 30.07. The handgun license holder who was trespassing was carrying their firearm in a holster.